All right, this is case number 08129347. This is Asset Acceptance LLC versus Montez Watson. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect regarding this matter that a judgment was entered on or about the 18th, it looks like, of July of 2008 for 3,200. And actually, I see the judgment entry on September 30th, 2008 for $3,425.26. And there is an effort here to collect thereon. I believe that the judgment was renewed at a subsequent time, October the 15th of 2018. And the effort here has been to collect on the judgment. Your appearance at this time, plaintiff, or the plaintiff. I have an appearance from Asset Acceptance. All right. Do I have Montez Watson on this zone?
The attorney for them, she was in a, she's in Judge Hannah Johnson, she said. She was running a little late.
All right, gotcha. All right, do I have Montez Watson? Please say something if you're there, Montez Watson. All right, I'm not hearing a response from the defendant. I've received a notation that the plaintiff's counsel is in another courtroom. So I'll do the courtesy of waiting for a few minutes, and I'll recall that matter shortly. The court now calls case number 21-160888. This is Kara Carson versus Oliver Management LLC and Arnold Oliver and Evelyn Oliver. The matter is before the court after the court issued a order on a motion for a more definite statement requiring that such be made on before October the 11th of 2021. Today is the date and time set for a pretrial conference hearing on this matter. Your appearance for the plaintiff at this time.
Hello.
I have your appearance now for the defendants in this matter. Counsel for defendants.
Scotty stepped away for a second. We had another court we had to go into.
All right. Do I have Kara Carson on the zone?
Yes. Yeah.
All right. Good morning to you, ma'am.
Morning.
All right. I am going to rename yours so I'll know exactly where you are, and then the attorney on the other side is in another courtroom, so I'm going to come back to your matter in just a moment.
Okay.
So just stand by. I'm looking now to case number 21-150-497, Integrated MRI versus City of Detroit. The matters before the court regarding the settlement conference. Your appearance at this time for the plaintiff, Integrated MRI.
Good morning, Your Honor. Danielle Lofton appearing on behalf of plaintiff.
All right, good morning to you, Ms. Lofton. Good day to you. For the defendant in this matter, and Ms. Lofton, your P number for the record, if you will.
It is P83625.
All right, thank you. And for the City of Detroit, your appearance at this time, please.
Joel Ashton for the defendant, P number 47039.
All right, thank you, Mr. Ashton, and good morning to you as well, sir. All right, so in less than a polished legal way of saying it, what gives here? I know that there's been some settlement discussion stuff. Talk to me.
That's correct, Your Honor. We attended a facilitation. There was a recommendation made by the facilitator. Since then, we've been speaking with the City of Detroit and also with the provider. We don't have an agreement on a number yet, but it looks like we're pretty close because I think we're both kind of dancing around this recommendation from the facilitator.
So the facilitator may have helped. We don't know if this facilitator helped or not yet. All right.
He's helped. He just hasn't quite gotten us across the finish line yet.
Got you. Ms. Lawson?
That is correct, Your Honor. I'm assuming if we could just have a little bit more time, hopefully we could wrap this up. But opposing counsel is correct that there was an offer and we're kind of dancing around it. Hopefully all parties can agree to that.
All right, well, let's keep it, let's try to keep it this year and see if in the interest of the holiday season, and maybe something will happen. So I'm going to set it out for maybe 30 days down.
30 days, like 11,
Sorry.
30 days would be 11,
Wow.
29.
Keep me in November, the last 29th of November.
Yep.
November 29th. And let's bring it back. I'll take a look at it at that time. If you get something resolved before the end, then let me know. Otherwise, November 29th at 9:30 a.m. And I'm going to indicate that matter is set for review.
Thank you, Your Honor.
Very good. Thank you.
All the best to you.
Thank you. You too.
Take care. Bye-bye.
It looks like I see Mr. Sagadi here. I've called this matter 21-160-888, Carson versus Oliver Management LLC and Arnold and Evelyn Oliver. Ms. Carson is present on the Zoom. Your appearance at this time for defendant, sir.
Gary Sagati, Your Honor, P39047, on behalf of all three defendants.
All right, thank you, counsel, and good morning to you. So there was a motion for a more definite statement. It looks like I received something with a date of 10/27 on it regarding a claim of various damages. Counsel?
I received that, Your Honor. Make sure we're talking about the same thing. It was just an itemization of things and then a round number claiming the damages. I believe it was 3 pages.
Yes, sir.
Okay. That's the only thing I received, but that was consistent with your order.
Yeah, so you're gonna need some time to respond to that, or what's your position regarding this matter, counsel?
I would need some time to respond, Your Honor. I'd like the Ms. Carson maybe not to go to breakout room. I made her an offer to settle the case, and if she accepts that here today, we could put that on the record and I can get her paid within 7 days. Otherwise, we're going to have a discovery order and maybe an order allowing us to communicate by email.
All right, I'm going to certainly send you to a breakout room to discuss the parameters of a possible agreement and or counter offer. And I will say that obviously, if there's not a resolution, then I will have to set a schedule in order. Of course, that's going to probably mean that this case would not get resolved until maybe somewhere around the 6-month point from now. And also, as I looked at some of the claims that are brought in here, obviously there would not be the ability to recover on all of the items that have been set forth, even if I took everything at face value. But it does appear that there are some damages that occurred, and that there might be some relief that's warranted there. So it's worth talking about to see if you can reach a resolution. An offer has been made, and maybe there'll be a counter offer. I'm going to send you to a breakout room You're gonna receive a notification from me, for breakout room number 1. Talk about it in the spirit of at least trying to cooperate and, see if you can reach a resolution. If you can, it works, and it can be resolved, in a short period of time. If not, then, we'll put it into the pool of other cases and we'll go forward to court. So there's your notification. And I wish you well on that. Come back in after you, had your discussions. Did you want any of your clients to go in? I see that there's, Evelyn Oliver. Ms.
Yes, Your
Oliver,
Honor.
did you want to go into that breakout room, with Mr. Sagati?
Yes.
Okay, I'm gonna send you there as well. Now, don't get into no fights or anything, let your lawyer talk, okay?
Okay.
All right, do your best, okay? Ms. Oliver, you got your notification? All right, this is case number, do I have counsel for Goldkey, please? Counsel for Goldkey? I see that I have Tawana Mitchell, and I know the case is at 10 o'clock, so I was looking to see if I had the other side. I'll come back to it in just a moment. Mr. Holzman, which matter are you on, sir?
I believe it is Michigan First versus Ms. Calhoun.
All right. I see Ms. Calhoun there, so I'm going to call that matter. This is case number 19-155900. This is Michigan First Credit Union versus Dallas Calhoun. Matter is before the court on a petition objecting to a writ of garnishment. The record should reflect regarding this matter that there was a judgment that was entered in this case. Looks like the judgment date in this matter was the 23rd of September 2019. That judgment was entered by consent for the total amount of $8,942.56. The garnishment, the writ of garnishment seeks to recover under the entry of that judgment. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Daniel Holzman, P82344 on behalf of the plaintiff.
All right, thank you, counsel. And your name for the record, ma'am.
Sure. Good morning, Your Honor. Dallas Calhoun.
All right, thank you, Ms. Calhoun. And Ms. Calhoun, these are your objections to the writ of garnishment. And you, on the form that you submitted to the court, you checked the part that said this writ was not properly issued or is otherwise invalid because, and you didn't put any because there. Why are you saying that this writ, I guess, is this a income tax return or lottery winnings? What is it, ma'am?
You know what? I'm not sure. I know they gave me a couple of forms to fill out when I came in. A young lady was assisting me.
Let me stop you for a moment. My specific question now is what type of funds is this with Michigan Department of Treasury? Is that a income tax return, is it wages? What is it, ma'am?
It looks like it was for both, for income tax and for garnishment of wages.
All right, got you. Now, you did respond by putting in the form, but you didn't give any specification as to why you think that the garnishment should not be effective. Tell me what you want me to consider here.
I'm correct. I was on a payment plan with them before COVID. I am responsible for that amount, but I hadn't been working, and I didn't receive anything from them, so I had no clue that any of those things was taking place. But I haven't worked in probably almost 2 years, so I don't have anything. When I do receive employment again, I was gonna, reschedule and try and get caught up with what I was paying before the pandemic took place when I was working.
All right, ma'am. So do you know how much money is being held up at the state treasury?
$1.
Exactly.
$1.
$1.
All right. All right. Well, I think it's kind of a good question here. What happens is if there is not an agreement to withhold from or just to refrain from using the garnishment approach, then the plaintiff, so long as there's a judgment in place, they do have the right to use the writ of garnishment, and that's what was done in this case. And obviously, when the judgment was entered, there was a payment agreement. And as you stated, Ms. Calhoun, that once you're able to get back on that agreement, that's what your desire is. Basically, they've not found anything that's really collectible. So my position here would be to deny the objections, and that dollar would be released to the defendant, to the plaintiff. The dollar would be released to the plaintiff to go towards the judgment. So it's kind of really like nothing happening here for sure. But a garnishment can be put in place anytime there is not an agreement to refrain from using the garnishment. And there are a couple of different kinds of garnishments. One is periodic, another is non-periodic. One affects wages. So when you have wages or a payment that you receive on a regular basis, a garnishment can be used to collect wages. But there's also garnishments that can be used to attack a bank account or attack funds that might be due to you with the state. Those are separate, different type of garnishments. And so this is the latter one where there is an attack against a particular asset that may be existing at one time, rather than a garnishment that is continuous, like a wage garnishment. So there's really, the question is really like almost a moot question. There's nothing here. The plaintiff has the right to garnish because there's no agreement to the contrary. And they've been successful in the garnishment here, but that only amounts to $1 under these circumstances. So I'll deny the objection, but I think everybody understands what this case is right now. When you get in a position, as you indicated, you back to work, it is a prudent thing to get a hold of the plaintiff's office, and let them know that you want to get back on the payment plan, because it's that would typically mean that they will refrain from other type of actions to collect, so long as you are on the agreement. But you got to clear that up. Once you're in position, call them so that you can say, look, this is what I want to do. Hopefully that will keep us from the garnishments so that I can pay this down over time based on our agreement. You understand, Ms. Coleman?
I do. Okay, well, I guess a question. So right now you're saying there's nothing you can do. I need to reach out to them. Although I'm not working right now, because I'm hoping, I have some interviews, I'm hoping to start back working. So I guess I'm trying to clear it all before I get back in there to, get it cleared up with the.
You still, the ideal here is that, of course, you still have the judgment in place. As long as that judgment is in place, the plaintiffs have the right to go after trying to collect that in any way that they can, any way that the law permits them to do that. And one of those ways is to file the garnishment with the state of Michigan. Obviously, if you were collectible in some other ways, they would have taken some action on some other stuff already. So obviously, the sooner that you get back to work and able to pay, that works out for you, it works out for them as well. But in the meantime, if they think that there's some money in a bank account, they could garnish a bank account that has your name on it. None of that. This is just a and it just so happens that there's only $1 there. Counsel, anything further you wanted to bring to this discussion, sir?
No, I was just going to inform the defendant, once you obtain new employment and your financial circumstance more certain, you can certainly reach back out to our office to try to get back on your payment plan. Or if for some reason someone in my office isn't agreeable to that, you're always free to file a motion for installment payments with the court. The judge here to decide what would be a fair repayment for you of this debt. But for the time being, if you're not working, we can't garnish any wages because we're not bringing in any.
Okay.
So that, I know you're concerned about what happens next month. So when you don't have anything that they can go after, the threat of them going after it is there, but you don't have anything for them to go after. So the ideal here is for you to do what you've been, that is to keep looking for the next opportunity so that you can set this up and get some control over it. You understand me?
Absolutely, and that's what I want to do. Okay.
I do wish you well. Good day to you.
Thank you.
Thank you, Your Honor. Thank you, Ms. Calhoun.
Okay, thank you.
Thank you, sir. Good day now. And I see Ms. Carson is back and Mr. Sagadi is back in this matter. And Mr. Sagadi, update you, sir.
We were unable to complete our discussion, Your Honor. I'm traveling and my cell phone battery ran out of juice, so I parked, plugged into my cigarette lighter. Could you please put us back in the breakout room?
All right. That's what I'm going to do. You actually, Ms. Carson, you can go back because you already have the notification, ma'am.
Okay.
Do you know how to do that, ma'am?
Yes.
All right, just go on back. And Mr. Sagadi, I'm going to send you back.
All right.
Thank you.
And your client is there already, sir. Do I have counsel for Golke? And Ms. Mitchell, I see that you're still there, so I'm trying to see if I can get the other side of here, so just hang tight.
Okay, thank you.
All right, okay, got it.
The other attorneys for assets said she's on her way back.
Got it.
For first.
All right, this is case number 21-144724. This is Protector Window and Door Incorporated versus Ronald Benson. Matter is before the court, settled before a trial on today's date. Your appearance for the record for plaintiff counsel.
Attorney Michael Norman appearing on behalf of Protector P75844, Your Honor.
All right, thank you, counsel. Good morning to you. Do I have Ronald Benson on this Zoom as well? I think I see somebody's lips moving, but you will need to unmute so that I can hear you. *6 will do it. All right.
Yes, this is Ronald Benson.
All right, thank you, Mr. Benson, and good morning to you as well, sir. Have you all talked about this, counsel, to see if you can come to some resolution that might make this work, sir?
We have, Your Honor. We have not been able to reach a resolution at this time.
And so the extent of your claim in this matter, Mr. Benson, you're asking the court to award how much money, sir?
We are requesting that Mr. Benson pay the outstanding balance on the account along with attorney's fees. So the total we'd be asking for at this point is $5,552. The outstanding balance on his account without attorney's fees and costs is actually, and I want to make sure I give you the right number, Your Honor. $2,446 is what is unpaid on the actual contract. The remaining amount of $1,500 is for the filing of the complaint, and then the attorney's fees protector is paid.
Okay, you said 1,500 for the filing of the case?
No, $206 for filing and service, Your Honor, and $1,500 for attorney's fees to date for protector.
All right.
I do not agree with that, John.
I didn't ask you that yet. You know I'm coming to you. I don't think we'd have a case if you agreed with that. You know, we already resolved. So I hadn't come to you just yet. It sounded like Mr. Benson, Mr. Norman, you said to me at the beginning that you requested for judging 5,500. When I add up the numbers that you just indicated, it would not come to 5,500. Did I get something wrong?
No, I think I did something wrong, Your Honor. So it would be
Oh yeah, it only needs to be rough numbers at this point. So, Mr. Benson, you jumped the gun on me and told me that you didn't agree on that. That didn't come as a surprise to me. On the surface, for purposes of discussing a way to resolve this, is there any amount that you believe? Don't tell me what the amount would be. You believe that you're responsible for any amount?
Do I say it again, Your Honor? I couldn't hear you.
You don't have to tell me any dollar amount, but do you believe that you are responsible for any amount, that there may be some money that you owe to protect the doors?
Well, it may be some money that I owe, but
right.
the thing.
Thank you. I just need to hear that part. All right. So here's what I want you to think about. I want you to take a moment, and I'm going to go to the case and think about what your number might be for purposes of settlement. And Mr. Norman, of course, is thinking about the same thing from his client's perspective as well. What may be your number for settlement? And then I'll come back to you and we'll have a little bit of a discussion. I'm ready to try the case, but if there's a way to bridge the difference between where you are, Mr. Vincent, and what would work for protectors, maybe both sides can give a little bit and find a way to a conclusion. That's what I'm getting at. If that's not possible, the trial option is always there. And today is the date for trial. Sometimes in the vast majority of cases, people find it more reasonable to find a way to work out their differences. But of course, sometimes things have to go to trial. I was a trial lawyer and I'm a trial judge, and I had absolutely no problem with those kinds of things. But sometimes if you think about it a little bit, maybe you can find a way to reach a conclusion. Like, for example, counsel is asking for actual attorney fees. There may be something in some provision somewhere that might allow that. The court is probably not inclined under the settlement scenario to grant the entire amount of what might be styled as attorney fees. So there may be some room to compromise. So both sides think about that. I'll come back to you. Thank you, Mr. Norman, for your patience in this regard. Thank you, Mr. Benson.
Thank you.
All right, thank you.
Mr. Sagati, you're back too quick. So are you, Miss? So Miss Carson, you're back way too quick. What's going on? Mr. Sagati, you there?
Yes.
Yeah, I see you, Miss Carson. Trying to reach Mr. Sagati. I see his device, but I'm trying to get his attention. Mr. Sagati? All right, I'll come back to you guys' case just a moment. I know you've been hanging in there. Just hold on a second. I'll be back to you. I'm looking at counsel, Mr. Nate. What case are you on, sir?
I'm on the Midland Credit versus Brandy Conneal.
Gotcha. This is case number 21-160-531. This is Midland Credit Management Incorporated versus Brandy Corneal. The matter is before the court settling for a settlement conference is what I have. It looks like I haven't set a scheduling order on this, but it looks like it's set for a settlement conference. Counsel, your appearance for the record at this time, sir.
Sure. Preston Nate, P77884, appearing for Midland Credit.
Thank you, Mr. Nate, and good morning to you, sir. All right, I'm looking for Brandy Corneal. I know that this is set on for 10:15, and we're just past that time. Ms. Corneal, are you there? Brandy Corneal? And counsel, have you had any discussions with Ms. Corneal leading up to this court date? Any contact in that way, sir?
Unfortunately, we have not. Looks like the last time we had a hearing in September, she was unsure about the balance and we were going to accept some documents. So hopefully she received those, but that was the only contact we've had.
All right, regardless of it, I've got some other advice. Okay, you indicated, counsel, and something happened. You indicated the last time that you were here, there was something about exchanging documents. So I'll say that again if you want.
Yeah, she looks like she indicated that she was she acknowledged the debt but was unsure of the balance. So we were going to send her some statements. Looks like we did get those prepared. Hopefully she received those. Like I said, we haven't had any other contact besides that. So.
All right. So we're just past the time for this case, and I know that the document that went out to Ms. Corneal does have the correct Zoom address. I'm going to give it just a couple more minutes to see if maybe she's having a problem logging on, and then we'll take it from there. So I'll come back to you in just a couple minutes. All right.
That sounds good. Thank you.
Thank you, sir. And Madam Counsel, Ms. Norris. Good morning to you. What matter are you on? And I think you're on mute at this time too.
Good morning, Your Honor. Can you hear me okay?
Yes, I've got you now. And I think you're on asset acceptance versus Montez Watson, correct?
Yes, Your Honor.
All right. This is case number 08129-347, asset acceptance versus Montez Watson. The matter is before the court on objections to a writ of garnishment. The court previously established a record as to the entry of judgment in that matter, as well as the renewed judgment that was entered in October of 2018. And this is a garnishment that indicates Fisher Weekly, located in St. Clair Shores. All right, and your appearance at this time, Madam Counsel.
Thank you, Your Honor. Attorney Ashley Nonis on behalf of plaintiff P77029.
All right, thank you, counsel. Do I have Montez Watson on this Zoom? Montez Watson, if you're on the Zoom, please say something at this time. This matter was set on at 9:30 a.m. The correct Zoom address was sent to defendant at an address on Ford Street in Roseville, Michigan. Do I have Montez Watson on the Zoom? All right, I note the objections in this matter. It says, it checks the box F, which is the writ was not properly issued or is otherwise invalid because I was not served. That doesn't tell the court much, but it certainly sounds like there's a claim of non-service related to a judgment that was entered in 2008 and then renewed in 2018. I note further that the address on the register of action is the same address that was used by Mr. Watson regarding this particular motion. Just one moment here. And while the court does not have the original file in this matter, that kind of claim of no service is not something properly brought in the context of a post-mortem writ of garnishment. The defendant has not appeared, moreover, and on the basis of all of the foregoing, the court will deny the objections, deem that they are invalid, and release any funds to the plaintiff at this time. It is so ordered, and I'm signing an order consistent therewith at this time. Thank you, Madam
Thank you, Your
Counsel.
Honor, and thank you for your patience. I appreciate it.
Yeah, all right, perfect. Have a good day.
Thank you, you too.
Judge, the last one from Ms. Brand, she came in and said that she must read the.
Okay.
The thing. She's here.
All right, bring her in. Ms. Corbeil is present in the court building, counsel, so I'm going to go on the record in your matter in just a moment.
Sure.
Yes, Mr. Sagatti, I know that you had a chance to talk in a separate room with Ms. Carson.
Thank you, Your Honor. Just to let you know, I'm trying to handle my technical difficulties right now. I am talking to someone in my office via OnStar in my car. They're going to zoom in, and if I lose you again, they will translate for me, if that's okay. But we were unable to settle the case, so I would be asking for an order that we can communicate by email. I will submit that for your signature. Ms. Carson has agreed to that. And I would also ask for discovery, seeking 90 days of discovery.
All right. And Ms. Carson, is there any information that you believe that you need from the other side in order to prosecute your case, ma'am?
Well,
You break it up a
Ms. Carson. That's my phone number. He just insists on being my email. And I forgot what I was going to say. Can I get with my receipts when I moved out? That's with my things. So receipts that I do have. I moved it out.
Ms. Carson, I muted you. And the reason I muted you is because I can't understand anything you're saying. Is something wrong? Is something wrong with your device? Maybe you're too close to it. Maybe you have two devices on at the same time. So I'm not able to hear you. It's goggled. If you could try to adjust things, then unmute yourself and.
Okay. Okay. Here I am.
There you go. Okay. Clearly now. Okay. What were you saying, Ms. Carson?
Yes, I said that, yes, he has my phone number, but he insists on email, which is okay, I guess. I had pictures when I left the house. I cleaned the whole house out. I had pictures and dates of it. I just didn't get to turn it in or whatever. As far as my receipts, I have receipts of some of the stuff, but I was just trying to keep the house cleaning up together or whatever like that. I had to do so much cleaning, and half of the time it's just a lot. I don't really know what I need from them at this time, but.
All right, ma'am.
Because I'm confused right now. I got a lot going on.
Okay, I got you. You know, and that's all those kind of things are understandable, man. So what I'm going to do is I will allow a 60-day period for the parties to exchange information. That means that they can send questions to you. You can send questions to them. You can demand documents in writing. There are a number of things that you can do. You put in writing and ask for any information that you may need from the plaintiff, and they can do the same thing as it relates to you over the next 60-day period. And then I'm going to set a hearing just beyond that time to see if there's any room for the parties to come closer together. I know that these kind of cases, because I've been a judge 29 years, and I spent a lot of time handling landlord-tenant type cases where damage has occurred. And so I know how complicated some of this can get with with there being some damage that occurred. So a lot of times there has to be an exchange of information to try to get, to try and drill down on exactly what occurred and what the dollar amount should be. So this process should help to reduce some of that and make it clear to both parties exactly where they are in terms of what the damages are. So when I put it over for 60 days, that means that I'm going to allow the month of December, excuse me, the month of November and most of December. So, and actually that's going to take us through December. So your next time back is going to be in January. So I'm looking at a hearing date of January 10th. So I'll allow discovery to remain open through January the 10th, 2021. That date, the hearing on that date is going to be at 9:30 a.m. January 10th, 2022 at 9:30 a.m. You'll get a document from me regarding this matter, and that written document is going to say that either party can file motions, can file a motion or motions with the court and set those motions for hearing on the 10th of January, 2022 at 9:30. So long as when you file that motion, you make sure that the other side has at least 7 days before the hearing to respond to the motion. So if you file something, you're asking the court to do something on that date in the form of a written motion. If you file your motion, you got to make sure that the other party has at least 7 days to respond to that motion before the hearing. And if that is the case, then I will hear the motion on 10th of January, 10th of January, 2022 at 9:30 a.m. In the meantime, I wish both parties well. Discovery is open. You can ask and make inquiries, put in writing what you want, and the other side is obligated generally under the court rules to supply the information that you request. All right. Good day to both of you. You'll get a written document from me in the mail regarding the scheduling of this matter. All right. Good day, Ms. Carson. Good day, Council.
All right.
Okay, we're back on the record in 21-160531 Midland Credit Management versus Brandy Cornell. The matter is before the court, settling for a settlement conference on today's date. I have received the answer to the complaint in this matter. And basically, the answer agrees pretty much with the complaint that was filed in this matter. And counsel, Mr. Nate has entered his appearance regarding this case. I was looking for Ms. Cornell on the Zoom, but she's appeared in person in the courtroom. And Ms. Cornell, state your name for the record, ma'am.
Brandy Cornell.
All right, thank you, Ms. Cornell, and good morning to you, ma'am.
Good morning.
All right, so and Mr. Nate, you can see he's there on the screen. That's what I'm looking at. He's the attorney for the for Midland Credit in this matter. Mr. Cornell, so what's going on here? And I'll come to you in a moment. Is there really a disagreement, or are you at the place where both sides agree on what the numbers are, or do we need to do some things further? Sir, to the best of your knowledge.
Well, from our perspective, I mean, we're always happy to maybe work something out. Like I said, from the last time we talked to Ms. Cornell at the last hearing, she, like I said, doesn't really dispute the debt, but it sounds like there was a question on maybe the overall amount. Did you ever receive the documents that were supposed to be sent to you, Ms. Cornell?
Yes.
Okay. Did you have a chance to go over those, or any questions about that?
I didn't have any questions besides the ones I asked to last meeting we had, that they was charging me over what I owe.
Okay. Like I said, I mean, I do have a little authority. We're definitely willing to maybe talk and work out a settlement if that's something that's possible. I don't know from your end if that's something you want to do or look into, but that's fine on our end if we wanted to discuss that.
All right, and basically what they're saying is that they may be willing to compromise on the number if it's a reasonable compromise and things like that. So let me ask you, you had a chance to kind of think about this. Do you believe that there is something owed?
Yes.
All right, and do you have, and you don't have to answer right away, think about it. Do you have some figure in mind that you would like to see this case settled at? Some offer that you make, that number would work for you if you could settle it at that number? Before you tell me what that number is, if you have a number, tell me whether or not you have a number in mind that you think the case should settle.
No.
You ever thought about it?
No.
All right, so their complaint asked for $4,800. Take a moment to think and come up with a number that you think it should be resolved for. Now, and whatever number you think, you think about it. Think about what you believe you owe, or what you believe the case should settle for, and then let me know what you believe that number is. Keep in mind that whatever the number is, you don't have to pay it right away. Of course, you could do that. You would likely be entitled to an installment agreement that you could pay it over time, et cetera, et cetera, et cetera. So, you know, there are ways to work out how you pay it. But the first thing we have to get to is to see whether or not the parties can come together on some number. And if you have a number, think about it. And if you'd like to put a number on the table, then do that. And we'll talk about it, see if it works for them. And if it doesn't, then we can go to another, approach it in a different way.
Okay.
No trick bag, okay?
Okay.
And any number that you want to put. So I'm going to ask you to do this, and I'll come back to you. I'm going to ask you to take a seat, think about it a little bit, and then if you want to put a number up, after you thought about it, then let me know. If you don't want to put a number up, just say, I don't want to put a number up, and then we'll go and see if Mr. Nate wants to put a number up, and we'll go from there.
Okay.
All right, so just take a seat for a couple of minutes. You can stay up here. You can
Okay.
sit right there. And Mr. Nate, just gonna give Ms. Cordero a few moments to think about it. And then she'll let me know whether or not she wants to put a number up that may be something that she would like to resolve the case at. If that works, it works. If not, we'll do something else. Okay? Thank you, sir.
That sounds great. Yeah, well, we'll come back to it.
All right, thank you both for your patience. All right, and I haven't forgot about you, Mr. Benson. I'm coming to you in just a moment here. I'm looking now to case number 21-67633. This is Robert Orthopedic Services versus Progressive Insurance. Matter is before the court. I sent it over for today's date for a review. And for the plaintiff in this matter, your appearance, sir. Do I have, I believe, Mr. Michael Fortner?
I have not seen Mr. Fortner. I tried giving him a call, but I got his voicemail, so I don't know what to say about that. He wasn't at the last hearing as well.
So what's the status of things? I see that there is an answer filed, of course, a jury demand, so on and so forth. Have the two of you had some discussions regarding this matter to try to get it resolved, or update me if you can?
Yeah. So I got a settlement demand from plaintiff. I submitted an offer to him. I didn't have a response. This case is really dependent on Mr. Dudley's underlying PIP suit that's pending before Judge Lillard. That's scheduled to go to trial on January 24th.
All right. So if you can get it resolved, I guess the better thing is just put it on the other side of that matter that's scheduled for trial.
Yes.
All right, so I don't know, of course, like yourself, Mr. Fortner was not here, but I do appreciate your collegiality in trying to bring this forward to the court. So I will go ahead and set it over in January. What's that date of trial?
January 24th.
All right, sir. Let's look to February 1st, actually.
Okay.
2/1/21 and 9:30 a.m. I'm going to treat that as a final pretrial conference.
Okay.
I think either the case will be resolved by the time, but at least we'll have a better perspective on where the case is.
I would think so.
All right, thank you, sir, and I'll make sure a notice gets out in that.
Thank you, Your Honor.
Okay, I'm back to protector windows and doors. I know you're set on for trial. Mr. Benson, I put out to you a proposition to kind of think about this and think about whether or not you want to put something on the table to talk about, to begin a discussion about whether or not the case can be resolved. You want to try to do that, sir? You don't have to tell me a number. Would you like to try and do that? You're muted. Yeah, get off. There you go.
Yes, sir. I would like to get the case resolved.
Okay, all right, gotcha. I want you to tell me a number. Here's what I want to do then. I want to send you and Mr. Norman to a breakout room, and you let Mr. Norman know what that number is, and let's see if there is a talking position from there to try to get this resolved. So I don't have to know the number right now. And let's see how close we can get here. And Mr. Norman, I know that there is some, well, you've heard kind of what my concern is there. There would have to be some compromise on some of these issues to try to get this resolved. But let's see if there is some room to perhaps make that happen. So I'm going to send you to breakout room number 2. You're receiving a notification from me now for that purpose, and then you can begin that discussion.
Yes, Your Honor.
Norman, did you get your, did you get
No, I haven't gotten the,
I sent the wrong person. I have to get them out of there. I definitely sent the wrong person. And they
got it.
So let me get them out of there.
Now I don't know what to do.
You wait.
I just wait.
All right, and as we're waiting on the protector window case, let me have you come to the podium, Ms. Cornell. Thank you. And we're back on the record in 0531. This is subjects on this matter. And of course, I sent someone to the breakout room and they're trying to get that. All right, so Ms. Cornell, I know I gave you a proposition to think about this matter. Is there, do you want to put something on the table for discussions or?
Yes.
All right, so if I had an opportunity, I would send you to a breakout room to do it. I really don't have the opportunity to kind of set it up that way. So go ahead and communicate what you like to communicate. Let's see if there's.
State the number.
Yes.
2,000.
All right. She'd like to resolve the case for a total sum of $2,000. And would you be paying that all at one time, or you would need time to pay it over time?
Well, the numbers that I just came up with, I was wondering if I could pay like 166 for 11 months, and on the 12th month I pay 174.
And she's worked out a payment plan that number would work. 166 per month, and then the final payment of 174 would end it in a 12-month period. That's what you're saying.
Yes.
So she'd like to resolve the case for 2,000 with a 1-year window to settle under a partial payment agreement as a part of that resolution.
Okay.
Counsel, the lady with the thing with Trinity, you're with Mr. Nate?
No, I'm on my own. So if there's somebody else.
Oh, I'm sorry, ma'am. I'll be with you in just a moment. I thought that you may have been someone from the agency. All right. So Mr. Nate, you may.
Yeah. So I definitely appreciate your offer. Unfortunately, I do have a little wiggle room because I know there's interest rates and late fees that correct or understood. I don't have that much room, unfortunately, though. So I can't accept 2,000. I can go down to 3,500 if that's something that you can accept. The payment plan sounded fine, but unfortunately, I just can't quite go that low as an overall total.
All right, so you're quite a bit of distance apart, and if you could go to his client with direction from the judge saying that I think the case should resolve at $2,000 at $3,000, would that be enough for you to lock this case down?
Yeah, but would I have to pay more? Would it still be in a year time frame?
You could, if you wanted to keep it in a year, you would just adjust the payment, but you probably want to extend it out to maybe 18 months.
Yes.
If she could do it 3,000, I would recommend that. I can't force their hand, and she would need 18 months to do it, even payments over a period of 18 months to resolve.
Now, tell you what, I mean, if just because I know if we leave the court, it'll take probably a lot more time. If you can do 3,000, if that's an acceptable number for you, I can make that work on our end. And if you want to do it over 18 months, that's fine. That sounds like a good payment plan or whatever might work for you.
That makes sense to you?
Yes.
Yeah, it's a little higher than what you want to be. It's lower than where they want to be, but it's a workable way of doing it. And you have an 18-month period to make the payments spread it out. There will be no penalty to paying it early if you decided at some point that I just want to get this over with. Obviously, you do that.
Okay.
That makes sense to you?
Yes.
Nobody forced you to settle it?
No.
Makes sense to you?
Yes.
Also, the court didn't twist your arm too much to force your hands to settle it, right?
No, you're fine. Yeah, we're still with our acceptable parameters, so it's no problem.
It sounds like a reasonable resolution to me, and I will allow for the settlement along those lines, right? So I'll enter an order in this matter, consistent with what the agreement is. It will have the payment plan and everything in it. Is there any objection to setting the judgment aside at the end of the payments, so long as the judgment is paid out in full?
No, not really. I was going to suggest we could also I could draft up a conditional dismissal even, just avoid a judgment altogether. As long as you make those payments, you'll be fine.
Okay.
Now, that's a great concession there.
Thank you. I appreciate it.
All right. All right, so go ahead and take care of that. I'm gonna give you the email address that you can email that to the court, and then you'll get a copy of it. And if it doesn't say exactly what we talked about here today, you can just put something in writing and direct it to the court under this case number, and I'll review it because it should be exactly what the agreement is here today.
Okay.
Okay?
Yes.
All right, so counsel, the email address is Latifah, LATIFAH .Hunter at 36360H 36districtcourt.org. All right, if you'll get that over to me, I'll get it signed, and then a copy will be sent to you, and you can start out with the payments and go forward.
Okay, so no need to mail a copy for now over to Ms. Cornell, just straight to the court?
Yes, straight to the court, because the agreement is on the record. And, once it's already signed up by me, you'll get a copy.
Okay.
And
And like I said, if for some reason it doesn't say what we agreed to, what was agreed to today, then that means a mistake occurred. Like I said, it should be exactly what you agreed to, $3,000 over an 18-month period of time. There'll be a conditional dismissal as long as you make the payments, case is over with. If you don't make the payments, then it gets reinstated and the judgment is entered. It's still the same amount, but you didn't have to deal with the judgment.
Yeah, so just to confirm, we're doing 3,000, it's 166 a month, and did we have a starting date or when you'd like to make those payments?
Look at my calendar there, if you can see it. So in a minute, we'll be in November. Usually you want to pick a Friday when you want to start with your first payment. And I know that the holidays is coming up, but usually pick a Friday, three weeks or so from now, which would put you right at the 19th of November. That's usually what works for you.
Is it, can I look at my calendar so I can see? I would like to start with my payday.
Yeah.
And the 19th of November?
Yep.
Can I do the 12th? I'll be getting paid on the 12th.
You want to do it early?
The 19th, I gotta get it out when I get paid.
All right.
Honestly, we'll say the 19th, but if you want to pay it earlier than the 19th, if you leave it
Okay.
up.
Thank you. Thank
But
you.
that gives you an extra week, if you run into anything, so.
Okay.
Sounds good to you? All right, real well. And you'll get an order with all of that in place, okay?
Okay.
All right, I wish you well, ma'am. Good day to you. Thank you for coming in.
Thank you.
All right, all the best to you. Thank you, counsel.
Yes, Camille, I appreciate it, Your Honor. I'll get that right over to you.
All right, sir.
Your Honor, on Benson, we did not speak in the breakout room. We did not both in there.
You did not? What happened, Mr.?
When I got into the breakout room, Mr. Benson was kicked out, I believe, and has just logged back on.
That was.
He's gonna mail that to her. I think he mailed it to her.
I
mailed it to
think
her.
he's gonna email.
Oh, he's gonna email.
He's gonna email it to us and then he's gonna mail it to her.
Oh, we'll mail it to her.
All right, yeah, well, it should be from the court. Yeah, so the court will mail her a copy and she'll likely get a copy from the attorney's office. Okay. All right, so let me send you back, okay? I messed up and I realized I did, but I thought I then sent the wrong person to break. I had to set the breakout. Mr. Norman, you know how to go back to 2?
Yes, Your Honor.
Okay. I'm sending you the 2 now, sir. Okay. All right. And, ma'am, which case are you on? I know that Mr. Mitchell has been waiting here on Gold Peak. Under Trinity there, which case are you on?
Yes, Your Honor, I'm with Protect Your Window and Door. I apologize.
Oh, like that, no problem, no problem. Did you want to go to the breakout room too, or?
Yes, I don't know how to do any of this, so do I just sit here like this?
You'll see a notification come up that says, join breakout room 2. There you go.
Okay. Thank you.
All right, then we're on the record again in case number 02112052 Gold Key Lease Incorporated versus Tawana Mitchell. The matter is before the court. Let's see. An objection to a writ of garnishment. All right, Ms. Mitchell, good morning to you.
Good morning, Your Honor.
All right, I appreciate your patience, and I don't see the paperwork regarding your objection to garnishment. So tell me a little bit about the garnishment. I know that there was a judgment entered in this case, and that judgment was for over $8,000. And I know that it was renewed, so it was entered in 2002, and then that judgment was renewed about 10 years later. Yeah, it was renewed in 2012. So it's been going on for quite some time now. So what did the plaintiff garnish? Did they, was this state income tax, or what's the nature?
Well, they've been trying to garnish my state income tax, my bank, and my job. But this writ to garnishment, this objection is for my bank.
Yeah, okay, so is your bank Diversified Member Credit Union?
Correct.
All right, so what basis, you do have a judgment in place here. What basis did you give me saying that they should be able to collect on the judgment?
So this started back in 2002. I paid $19,000 on this judgment. And they were still saying that I owed them $14,000 the last time we went to court in 2018. I brought in the court paperwork for my job stating that that amount wasn't owed. That was the incorrect amount. And the lawyer was supposed to find out the information for the court. He could not give the court the information. So the judge said that they had to relinquish all funds to me. They had to give me all my funds back that they took. So now they're coming back again and they say I owe them $8,000, which is the incorrect amount again. So I'm assuming they still haven't did the footwork to find out how much I actually owe them. And there should be a copy in the file with the court from 2018.
All right. Well, I don't have the file. I do have a register of action. And I do see that there have been multiple garnishments over time. And it sounds like what you're pointing out to me is that the previous judge on this matter, that would have been Judge, a couple of people. Hold on a second. That would have been Judge Brew in 2018. In 2018, she denied the objections to objection to garnishment denied as invalid. The garnishee shall immediately release all of the funds to the plaintiff attorney. Plaintiff shall investigate, determine the current balance of the debt. So release the funds to them, and let's see what happens. Objection to garnishment held. Objections granted. That was the 23rd of May of 2018. So that's what you were talking about here.
Correct.
Order the garnishee shall immediately release all of the funds to the defendant. Release liability. Okay. Let's see what happens next. And then there are a number of other garnishments that occurred subsequent to that time. All right. So what? Obviously, you run into a problem when there's a judgment in place for this limit of time because you have of course incurred it before interest that continues to accrue. So that what I believe Judge Brew ordered was an accounting because an accountant would provide information as to how much money they collected over time, how the money was applied, whatever interest accrued, and then ultimately what the balance would be in that regard. I don't see where subsequent to that time where there was an accounting that was offered. I did counsel for the plaintiff has not appeared on this date. And while I see other garnishments that were brought subsequent to the order in 2018. I do not see any further judicial action taken by any court, by any judge. And for that reason, where the case remains at, the place where the plaintiff would be required to provide an accounting. And where the plaintiff has not provided an accounting, I would grant the objections to the writ of garnishment and will release any withheld funds to the defendant in this matter because the plaintiff has not complied with the court's order that the plaintiff provide an accounting. So the objections will be granted and any funds withheld will be released to the defendant in this matter. All right, ma'am. I wish you'll get a copy of my order releasing the garnishment and releasing the funds. You'll get a copy of that in the mail.
I understand that part. So I guess my question is, because they don't have any funds that's held, but my question is, can they still continue to come back and garnish me?
Yes, they can. And what you will want to do is, if they keep on garnishing you, you will want to file something asking the court to issue a sanction against them. The court to issue a sanction against them. That sanction could be an order prohibiting them from taking further garnishment. It could be an order requiring that they pay certain money. But you want a sanction because where the case is at now is that a garnishment, strike that, an accounting was ordered by Judge Brew, although she did not use that language. That is the nature of what she has directed, and no accounting has been provided. So until they provide an accounting, they should not be filing writs of garnishment. So they file another one, you want to object to it, but you also want to use the language. I'm not trying to be a lawyer, but I can, I'm the judge. You want to use the language that they are filing garnishments against me over and over again. I'm asking that the court would sanction them because Judge Brew ordered that they provide an accounting. They refused to do that, but they continue to garnish. Okay?
Okay, thank you.
Right, I wish you well, man. Good day to you.
Okay, thank you.
You sound like a person that lost today. You actually won.
I'm just at work. I'm trying to do multitasking, but thank you. I appreciate it.
All right, good day to you, man. I wish you well.
Okay, you as well.
No.
Yeah, here. No, that's not the same. This is funny. Stop slide. Mr. Sagati, why are you back to see me, sir?
When my phone cut out, there was a little bit of unfinished business. The only thing that we can handle ex parte is if you look at the ROA, I am shown as representing both the plaintiff and the defendant.
You're talking about on the case 0888, Carson versus Oliver Management, correct?
Yes.
And what's the problem that you're seeing, sir? She's not here now, but what's the problem that you're seeing on this?
I am shown as representing both the plaintiff and the defendant when I just represent the defendant.
Wow. I know that you do some borderline miraculous things, but I don't see how you could do that. So we're going to correct that to make sure that you are representing defendants in this matter.
Appreciate your faith in me.
All right, thank you, Mr. Scott. And you'll get that one.
Okay.
From me, regarding the scheduling shortly, sir. All right, good day.
Good day.
All right, and so I'm back on Protector Windows and Doors versus Ronald Vinson. I know that you had opportunity in the breakout room to have some discussions in this matter. It's kind of always easy for me to go to the attorney and get updated. So if you will, Mr. Norman.
Yeah, we were not able to reach an agreement, Your Honor. I won't mention any of the offers or numbers, but I think we'd have to proceed.
All right, very well. So let me then move us forward in that direction, if you will. The trial proceeds with the plaintiff having the opportunity to go forward first because the plaintiff has the burden of proof by a preponderance of the evidence to establish the proposition that they brought before the court. After the plaintiff presents its side of the case, it can do so by presenting witnesses, pieces of information, documents to the court as evidence of the claim that they are bringing before the court. As they're doing so, the defendant has the right to object. The defendant has the right ultimately to ask questions and to inquire about information and testimony that is being presented before the court. And the defendant may cross-examine the witnesses that are offered by the plaintiff in this matter. Likewise, once the plaintiff's case is concluded, the defendant has the right to present evidence by way of testimony, documents, and other sources that he believes might add to the information the court should look at in terms of determining the outcome of this case. The plaintiff has the right to object to testimony, information, evidence, documents that are offered by the defendant, and the court will rule upon objections that are made. The plaintiff also has the right to cross-examine or ask questions of the defendant in this matter regarding any testimony that may have been offered regarding the underlying claim and defense in this matter. That is the general nature of how trials proceed. Any witnesses that testify, persons that must be sworn, they must offer an oath that they will tell the truth and nothing but the truth. At the conclusion, both sides get an opportunity to give a closing statement, the opportunity to summarize what they believe the case has shown. In the end, the attorney for the plaintiff gets the last word because, again, the plaintiff has the burden of proof. So the plaintiff attorney will have the last opportunity to speak because he has the burden to prove the case by the preponderance of the evidence. Case starts with an opening statement. If the parties wish to make an opening statement, opening statement is a summary of what you believe the case will show. It does not provide proof to the court. It is simply a summary of what you believe the case will show. Sometimes the party will waive their opening statement, meaning that they don't want to offer it. They choose not to offer an opening statement. And at other times, the statement will be offered. So that's generally how a case proceeds. That information was primarily offered for Mr. Benson because I know he's not an attorney, and Mr. Benson is not represented by an attorney this morning in this matter. All right, Mr. Benson, you generally understand how to proceed regarding this matter, sir? Yeah, and you're still on mute. Mr. Benson, you're on mute, so go off. Yeah. All right, yes, Mr. Benson, you understand how this matter will proceed, sir?
No, not fully, but basically I'll just be telling the truth about the matter.
Yes, sir. You understand that if you have any questions of any witnesses that may be offered, you have a right to ask questions of those witnesses as well. You understand?
Yeah.
All right, so I'm going to begin now with Mr. Norman as he gets the opportunity to go forward first on behalf of his client. And sir, if you wish to, you may make an opening statement at this time, sir.
Yes, Your Honor, I'll make a brief opening statement. This is a contract case where Mr. Benson contracted with my client Protector to provide, to have some doors installed. My client did attempt to comply fully with the contract. And the only reason that it was not completely complied with is because Mr. Benson refused to allow the completion However, the evidence will show these are custom products, and therefore we're requesting the full amount of the contract in this lawsuit.
All right, thank you, counsel. All right, Mr. Benson, you may offer an opening statement at this time if you wish to, or you could wait until the beginning of your part of the case to give an opening statement. But you certainly can give a summary right now of what you believe the case will show, if you wish to do so at this time, sir.
Yes, basically, my opening statement is, the attorney, how do you feel that these, I didn't allow them to finish the job because I allowed them to finish the job. They did not finish the job. They breached the contract.
All right. All right, sir. Thank you very
Because,
much.
because they,
Oh, you still talking? Go ahead, sir. I'm listening.
yes, because the doors, the original contract, it was supposed to be, the job was supposed to have been completed in September. The job still is not complete, and they only installed 2 doors. That was in the beginning of this year, which was January, and the job was supposed to be completed in September. Each time they came out, they brought the wrong doors, and then they told me I had to eat the cost because they didn't finish the doors and didn't make the doors the right way upon the doors that I initially ordered. So $200 would be justified, and that's just in good faith.
All right, sir. All right, thank you very much, sir. All right, Mr. Norman, you may proceed at this time with your case, sir.
Thank you, Your Honor. And I would ask, can the court allow screen sharing?
I thought I already had it set up that way. Yes, you see it now? I believe that, all right, you may proceed, sir.
Yes, thank you very much. Your Honor, I would call Mr. Benson as our first witness.
All right, Mr. Benson, you're being called essentially as an adverse witness regarding this matter, and the attorney will have questions for you in this regard. All right, let me have you raise your right hand to be sworn at this time, Mr. Benson. You do solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth, so help you God, sir?
Yes, sir.
All right, very well. Mr. Norman will have some questions for you, sir. So go right ahead, Mr. Norman. You may proceed, sir.
Thank you, Your Honor. Mr. Benson, do you agree that you contracted with Protector Window and Door on August 28th, 2019 to provide two doors as well as 2 security doors on your home?
Yes, there's 2 interior doors and 2 exterior spiderweb doors.
And the total amount of that agreement was $3,846?
Yes, that's for the job being completed. All 4 doors, clean up, and everything done to my satisfaction.
All right. And so I want to talk about the contract itself. Do you agree that the contract did not specify a completion date?
The completion date is supposed to have been 2 weeks after I signed the contract. It was supposed to have been 2 weeks. Everything was supposed to have been delivered within 2 weeks and job complete within 2 weeks. The job was not completed at all. Half of the job, 2 interior doors that took all the way until January of this year.
Mr. Benson, can I ask that you just respond to the question that I asked, please?
Yeah, just one moment.
I'm responding as you asked. I'm answering as you asked. I'm just telling you about the contract of the job. So you don't exactly know the contract.
Can you hear me? Just hold on one moment. Ma'am, I'm sorry I didn't get your name, but you're sitting there nodding your head and all. You can't do that. So why don't you turn your camera off? Just go off your camera. All right, thank you. All right. Now, as to your question, counsel, it appears to me, Mr. Benson, that the question that's asked by Mr. Norman is whether or not the written contract has in the written document the completion date. Does it tell you the date upon which it should be completed, the services?
Well, I'm going on what they told me about, because it was within the pandemic, right before the
Let me stop.
pandemic, and they said the doors would be
Let me stop.
completed.
When you hear my voice, you have to stop. Let me stop you for a moment. Your understanding, based upon your testimony, is that the completion was to occur with the doors being supplied and installed within 2 weeks after the contract was signed. That was your understanding, correct? And your testimony here also is that as it relates to the written document does not contain that language, or it doesn't specify completion date. Is that correct, sir? Is that correct?
Can you hear me?
Mr. Benson? Yeah, I hear you now. The written document, the contract, it didn't give the completion date, did it?
Not the written contract, but what I was told when I signed the contract.
All right, thank you, sir. Back to you, Mr. Norman. You may continue, sir.
Okay, thank you. And so you admit that you did sign the contract on August 28th, 2019, and it did not specify a completion date.
Well, I don't see where it says completion date, but I'm going on what they told me.
Okay.
As first signing when I paid my $1,400 to them.
All right, well, I will move on. So can you see what I have put on the screen, Mr. Benson?
I see the bottom half of customer clear something in back way.
All right, but you can see what I put on the screen, correct?
Yes.
And to the right is your signature?
Yes, it is.
And the date of 8/28/2019?
Yes.
And that is the contract you signed with Protector, correct?
Yes.
And did you understand that you were ordering custom products that had to be made for your home?
Yes.
Okay. And do you agree that the last sentence, which appears there, says that every attempt will be made to complete the contract expeditiously? However, they can't be held responsible for manufacturing delays.
Where does that say that?
It says it right above your signature. If you look at that sentence.
Okay, I see that. But
Right,
can he call? He called the customer.
Sir, can you just let me ask you the questions, please? And you did sign that contract?
Yes.
Okay. All right. And so again, you understood you were getting custom products that had to be made.
Yes.
All right. And so
Counsel, excuse me for just one moment. I have to check one thing. Just one moment, sir.
Yes, sir.
Madam Clerk,
Yes, ma'am.
I'm gonna take 2 minutes also.
Okay.
All right. back.
And pardon the interruption, Mr. Norman, you can continue, sir.
Thank you, Your Honor. And Mr. Benson, just a procedural matter. Your home is in the city of Detroit, correct?
Yes, it is.
Okay. And you admit, sir, that on October 18th of 2019, Protector came to your home to begin installation based on the contract?
No, that was October 28th, 2019, not 18.
Okay, and sorry, 2019. In any respect, you agree that Protector came to your home to begin installation of the products you had requested, correct?
The attempted installation.
All right, and one of the things they were replacing was your front door that was existing, correct?
Interior, exterior, front and back.
Right, the front door, and they were also creating a new opening for a back door, correct?
Correct.
And on the first day they came to your home, they created the new back door opening, didn't they?
No, because the doors was wrong.
Did Protector at some point create a new opening for a back door in your home?
Yes, they did.
And did they install the door?
I think that was a week later. I think that was a week later.
Okay, and did they install a door in that opening?
They installed the wrong interior door.
What? Okay, but a door was installed in the opening on your home that they created?
Yes, and they left my house open and I got mice.
Let me stop you. Let me stop for a moment here. Mr. Benson, the reason I went over how things proceed is because you get a chance to tell me what you want to tell me, okay? You're gonna have your chance where you could just go through it and tell me exactly what you want to tell me. Right now, I want you to use your best effort to try and answer Mr. Norman's questions. Whatever the question is, for example, he asked you a question, did they make an opening for the door? The answer to that seems to be yes. Did they install a door there? That seems to be yes. You have some other things that you want to tell me about that. When I come to you, when he's done answering, done with their part of the case, I'm gonna come to you. And I'm gonna ask you, what do you want to tell me about this? And you'll be able to tell me whatever you want to tell me. A week later, they cut that hole in there. They put the door up. I didn't like the door. Whatever you want to tell me, you'll get a chance to tell me that. His questions are not trick questions. They're just questions that are straightforward, trying to find out what your testimony may be on a particular point, and limiting your testimony for purposes of his questions. But that does not cut off your ability, when it's your turn to talk to me, that doesn't cut off your ability to tell me exactly what you want to tell me. You understand?
Yes.
All right. In just one moment, again, Mr. Norman, Mr. Fortner, good morning to you, sir.
Sorry about that. 1 second, please.
You want his file back?
Yeah.
Yeah, you got it.
Oh, yeah. You're looking good, boy. I don't know. The older you get, the better looking you get, man. I don't know what's going on around here.
You'll never be able to persuade the judge with those notions, but you could.
How you doing? I don't know what we got today. Do we have?
You could remind my wife to say those things over and over again. That would help out a little bit.
I'll speak if I see her.
Anyway, the case that you're on, sir, we did call it earlier, and the gentleman indicated the other side was here and indicated that the parent case to this is in circuit court and is due for a trial date in January, and that that particular matter may help with the resolution on this if it is not resolved before that time.
True.
So what I did is I went ahead and set the matter over for February 1 because the trial date in the parent case is late January 25th or somewhere along those lines. And so it seemed that there is some notion that it might be able to be settled before that other case, but if not, the court would take another look at this file February 1, at 9:30 a.m.
Okay, Your Honor. That sounds like a winner. Thank you very much, as always.
Yes, sir. It's good to see you, sir. All right, have a good day.
Thank you, Your Honor, very much.
Thank you, sir. All right, Mr. Norman, you may continue now, sir.
Okay, thank you, Your Honor. I think, Mr. Benson, we left off that Protector cut a new opening for a back door in your home, correct?
Correct.
And they installed a door in that opening.
Correct.
And you also, at the same time, Protector installed a new front door on your home, correct?
Correct.
Now, the next thing is the other part of the agreement where they would install security doors, correct?
Correct.
And did Protector install a security door on the front door of your home?
Yes, it did.
All right. And did they attempt to install a security door on the back door of your home?
No.
Did you stop them from installing the security door on the back door of your home?
No.
So it's your testimony that they did not have a back door to install, a back security door to install?
No.
Okay, but you do admit they installed a front door, a rear door, and a front security door.
They installed two interior doors, front interior, rear interior.
And I just want to clarify for the court, when you say interior, it's the front door that goes from outside to the inside of your home, correct?
Yes, but it wasn't a security door. No.
Right, but they installed the actual front door,
the interior door, yes,
and the actual rear door.
Yeah, they installed the interior doors, and
they installed a security door on the front.
It was the wrong security door, so they had to take it back.
Did they install that door on your home?
Yes.
Okay, and they had the rear security door to install, but you told them that they could not install it, correct?
No, they said they didn't want to put it up because it would tear up the wood, damage the wood if they took it down to bring the correct door.
Okay. And then did Protector return to your home at a later occasion?
Yes, to pick up the doors.
And they were also there to install what you would call the correct security doors, correct?
Yeah, correct.
And did you tell them that they could not install those doors?
I sent them back. They was the wrong doors.
Now, let me share my screen one more time. What, in your opinion, what was wrong with the door?
It was supposed to have been a 3-tier spiderweb door, and they came out with a flimsy 2-tier spiderweb door. The 3-tier has like a spiderweb. It has that loop in there 3 times, but they only came out with the loop twice, 2 loops.
All right, and I want to take you back to the screen. The contract, the agreement was to install spiderweb security doors, correct?
Correct.
And they brought, is there anything on the contract, which I am sharing on the screen again, that says anything about 2-tier versus 3-tier spider webs?
No, that's not in the contract.
Okay, and so they were there prepared to install spiderweb security doors. The disagreement you had is regarding whether it should have been a 3-tier or a 2-tier security door.
Yes, it was the wrong door.
Okay, but they were there prepared to install them and you told them that they could not do that, correct?
I sent them back. I didn't tell them they couldn't install them. I sent the doors back.
Okay. I don't have any more questions for Mr. Benson at this time, Your Honor.
All right, thank you, sir. All right, thank you, Counsel. You may continue at this time, sir.
Okay, I would call Brian Little, the installer for Protector.
Hello.
All right. What is your name for the record, sir?
My name is Brian Scott Little.
All right. Thank you, Mr. Little. And is that spelled Little or some other spelling?
No, Little is correct.
Thank you. Raise your hand to be sworn in this. You do
No,
solemnly
John,
swear.
I didn't get his name. I'm sorry.
It's
Say it
Brian,
fast.
Bryan,
Uh-huh.
and Little,
Brian
Litt.
Little?
Yes, ma'am.
Thank you.
Raise your right hand to be sworn, sir. You do solemnly swear or affirm, Mr. Little, the testimony you're about to give is the truth, nothing but the truth, so help you God.
Yes, it is.
All right, thank you, sir. Counsel, you may proceed at this time.
Thank you, Your Honor. Mr. Little, are you currently employed?
Yes, I am.
And how are you employed?
So I'm a subcontractor for Protector Window and Doors.
Okay, and as part of that, do you install products for Protector Window and Door?
Yes. I install their doors, windows, stuff like that.
All right, and were you the installer on Mr. Benson's project?
Yes, I was.
Okay, and I think you overheard the testimony of Mr. Benson. Is that accurate?
Some of it, yes. Not all of it.
All right, well then let me just quickly go through. Do you recall what date you first went to Mr. Benson's home to begin the installation?
Not off the top of my head, but I can grab the completion of when I was there the first time, which was 10/18.
Okay, so the first time you went to Mr. Benson's home was 10/18 of
2019. Yeah.
And can you tell the court what you did on that day as far as installations?
So I went there with one of my employees. While he was taking care of the front door, I was cutting the opening and installing the back door at Mr. Benson's house.
Okay, and tell me what products did you completely install on the first?
We installed the back door, which I cut in, and then my helper installed the front entry door and the front security door.
Okay, and when you say cut in, can you explain to the court what that means?
So Mr. Benson wanted the opening moved from he has a landing going down to the basement. He wanted it moved from the lower landing to the kitchen because he was putting a deck on the back of the home. So he had the opening prep with no drywall and stuff like that. So we actually had to cut in and reframe to put in a header and stuff like that to install a door, which we did.
Okay. Now you mentioned that you installed the front door, the rear door, and a front security door. Did you make any attempt to install a rear security door?
He didn't want us to install it when he seen the front door because he said it was the wrong style. He did have me leave the door on site because he wanted the door there until we came back with the correct door.
Okay, so you left the rear security door, which Mr. Benson told you not to install at his home. Okay, did you then return at some point?
We did return on 11/3 of 2019 because the front entry door, he is correct, it was the wrong style, it had the wrong glass in it. So we did a slab swap on the front entry door. And then when I pulled out the new doors to show him, he was not happy with them. He went in the house and grabbed a Polaroid of his first house that he had, I guess, a long time ago, and said that the spider web doors didn't match. And I tried to explain to him that they don't make that style of door anymore. You know, different manufacturers, like like over 20 years old. Things change. And he refused the doors. And so we loaded up and left.
Okay, so when you went on the second occasion, you were fully prepared to install the spider web doors that were requested in his contract, correct?
Yes, I had both doors ready to install, but he did not want them.
Okay. And did you leave the, well, let me ask you this, the security door that was installed, what style of door was that?
It was a Peacock. That was that was originally installed was a Peacock.
And just for the court's satisfaction, I'm gonna share my screen here. Can you see my screen, sir?
Yes.
The door, I guess, to my right is the Peacock style.
Yes.
And the one to the left is the spider web.
Yes.
And on the first day you went to install, the doors that had been manufactured were the Peacock style.
Yes, sir.
Okay. And the doors that were supposed to be installed were the spider webs.
Yes.
Okay. So did you leave the Peacock doors with Mr. Benson when he refused to allow you to install the correct doors?
Yes, we didn't attempt to take any of the doors off just to leave his home secured. So the front door was left on and we never touched the side door. It stayed in his backyard.
Okay. So at Mr. Benson's property, there's a fully installed rear door, a fully installed front door, a front security door.
Yep.
And the rear security door, but it is not installed.
That's correct.
All right. And is there any reason other than Mr. Benson telling you could not install it that the security door was not installed?
No, he would not let us install it.
All right. And is there any reason other than Mr. Benson telling you that you could not install the spider web doors, that those were not installed?
No, no reason at all.
I don't have any other questions for Mr. Little, Your Honor.
Right, I do have a couple questions. You said something, and you might have just been talking about the back door. You said something about the side door. You had no deal.
Oh, I'm sorry. Yes, I meant the back door. There was no side door.
All right. Mr. Little, you were not a part of the contracting in this matter, correct, sir?
I am not. I'm just the installer.
All right. So you don't know if anybody showed Mr. Benson any photographs of a spider door versus a peacock door or anything at the time of the contract? You don't know anything about that?
No, I just know that he showed me a photo. He had a Polaroid that he took of his original home with the door that he said he wanted. And I explained to him they don't make that style anymore. And he wasn't happy about that. And that's when he refused the doors. But he's the one that showed me a photo, but I don't know if anybody showed him a photo or anything like that.
The photo that he showed you, if you recall, was that photo in fact a spider door or a spider web?
It was a spider web, but that was an older spider web that they made like in the late 80s, early 90s.
All right, thank you, sir.
You're welcome.
I don't have other questions. Any questions sparked by my inquiry, Council?
Yeah, I don't have any other questions for Mr. Little. Unless Mr. Benson does, I would call Trinity.
I asked you a couple questions. That's why I came back to you. Any questions sparked by my questions to Mr. Little? Any questions that you have as
no, Your Honor.
All right. Mr. Benson, do you have any questions that you'd like to ask Mr. Little at this time, sir?
Mr. Little, you say?
Yes, Mr. Little, the guy that came out, so any questions you want to ask him at this time? Remember, you'll get a chance to talk. You'll get a chance to talk to me and tell me what you want to tell me. But if there's something you want to ask this gentleman about, go ahead and ask him questions, sir.
Yes, I'd like to ask Mr. Little. Do you recall that morning that you was out there and you was working on the back door and the doors was the wrong doors? So I asked you, could you install that door as well? And you said no, it'd be best to leave the back door down. So because it will tear up the wood once you guys brought out the correct door to install. Do you remember? You recall that?
That is incorrect.
I'm sorry.
That is incorrect. The rear door was never the wrong door to begin with. Only the front door was wrong, and it was a different slab. It had a different glass. There was nothing wrong with the back door at all.
The back door, interior door was the correct door, but the rear security door was the wrong door. So you said it was best to install that security door for the simple fact that when they brought out the right security door, it would tear the wood up when they tried to take it off to replace it with the right door. Do you recall that?
No, because I wouldn't get paid if I didn't install the door. So me not installing the door makes no sense to me because I can install it and then I get paid to go back and reinstall the new door. So that doesn't make any sense.
But you do recall not installing the rear security door, correct?
Because you did not want me to, yes.
That's because you said that it would be best not to, right?
No, that's not.
You don't recall that?
No.
Okay, that's good. I have no further questions for you.
All right, thank you.
You was a great guy. You was a great installer.
Thank you, Mr. Benson. Okay. All right. Anything else of this witness, Mr. Norman?
No, Your Honor.
All right. Thank you, Mr. Little. All right, Mr. Norman, back to you, sir. Anything at this time?
I would call Trinity from Protector.
All right. All right. And your name for the record, ma'am?
Trinity Parks,
All right. And how is Parks spelled, ma'am?
Parks.
All right. Thank you. Madam Reporter, any inquiry?
I'm sorry?
Did she say Brandy?
No, Trinity. Go ahead and spell your first name.
It's TRINITY.
Okay, thank you.
You're welcome.
Thank you, Ms. Parks. Raise your right hand and be sworn in this. You do solemnly swear or affirm that the testimony you're about to give is the truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you, Ms. Parks. Ms. Parks, Mr. Norman has questions for you at this time. Mr. Norman, you may proceed at this time, sir.
Thank you, Your Honor. Ms. Parks, are you currently employed?
Yes.
And how are you employed?
I am the general manager for Protector Window and Door.
Okay, and are you personally familiar with Mr. Benson's contract and the job that was done for him?
Yes.
Okay. So I want to first ask you regarding the contract, are there any completion dates specified in your contracts?
No.
Okay. The products that you provide, are they custom products?
Some, yes, some are stock.
Okay, in Mr. Benson's case, were his products custom or stock?
Custom.
Okay, and can you explain to the court what a custom product means as far as your ability to reuse it or not reuse it?
A custom product would be a standard security door. Standard security door would be a 30 by 80 outside security door, something that I have in stock here. I order large containers of standard sizes, which are 30 by 80, 32 by 80, or a 36 by 80. Outside security doors, and I also do stock just standard 6-panel replacement entry doors and the same sizes of a 30 by 80, 32 by 80, or a 36 by 80.
Okay, and Mr. Benson's doors, was he any of those standard sizes?
He does have the standard size of a 32 by 80.
And which door is that for?
It's for the back door, but the 32 by 80 is the style is a wagon wheel. So it's not a 6-panel. So it's something that I do not stock.
Okay.
And the back security door needed to also be made, which was ordered as a spider web. So that also needed to be made because that is something that is not stock.
Okay, so just for clarification, all of the products used for Mr. Benson's home had to be ordered?
Yes.
Okay. And can you tell the court, if you're able, what the material cost is for you ordering those products?
My cost?
Yes.
I have it at roughly right around 1970. I don't have it down to the penny. I apologize.
No, that's fine. And so regarding Mr. Benson's installation, he did pay a deposit towards the install.
Yes.
Did Mr. Benson ever tell you that he did not, well, prior to installation, did Mr. Benson ever tell you that he did not want the job done?
No.
Okay. And so on October 18th, when your installers went out, did you have any communications with Mr. Benson after that?
After that, yes.
All right. And what was discussed in that communication?
The manufacturer sent us on behalf of Mr. Benson a different style outside security door. So for his front security door, the outside door, they sent the style called a peacock. And also the back security door, outside door, they sent a peacock, which was not what Mr. Benson had asked for. Mr. Benson asked for the spider web style doors for his front and back door.
Okay, and I would like to, let me share my screen one more time. Can you see the picture on my screen of doors?
Yes.
All right, and so are these well, do you know where these pictures came from?
Yes.
Can you tell the court where they came from?
These are the style of doors that are offered from my salesman to show this style to their customers. It's in their sales book.
Okay, so these would have been the pictures that the salesman would have shown Mr. Benson when he was making a decision regarding doors.
Correct.
I'm sure that
Okay.
she can't answer that question, so I'll sustain the objection that was not raised, just.
Okay.
She can't.
Well, but these pictures are included in your salesman's sales packets.
Yes.
All right. So did you, after you discovered that the doors were wrong, did you order the correct doors?
Yes.
All right. And did you then attempt to have those installed at Mr. Benson's home?
Yes.
All right. And do you know what happened regarding that installation? Do you have personal knowledge?
The installer, Brian Little, returned on October 3rd, 2019 with the two spider web doors, stating that Mr. Benson did not want these doors. He said that they were the wrong style.
I don't know that she can provide that testimony. Mr. Little can speak for himself. I will accept the testimony relative to Mr. Little returning with the doors uninstalled.
Okay.
She can't, Mr. Little said.
All right. So are you able, is your company able to reuse those custom doors that were made for Mr. Benson's home?
No.
All right. And do you still have those doors in your
Yes.
warehouse?
Yes, I do.
All right. And if Mr. Benson were to allow it, would you be able to have someone install those doors?
Yes.
Okay. And do you have any personal knowledge of how much is outstanding on Mr. Benson's account?
Yes.
And what is that number?
Off the contract, $2,446.
Okay. And did you have to spend money filing a complaint to attempt to collect this amount from Mr. Benson?
Yes.
And is that $206?
Yes.
And have you incurred attorney's fees in order to bring this claim against Mr. Benson?
Yes.
And do you know the amount of those attorney's fees?
Prior to today, 1,500.
All right. And are you asking the court to pay the outstanding, to ask to have Mr. Benson pay the outstanding balance on his contract, the attorney's fees and court costs in this case?
Yes. Yes.
Okay. At any point, did Protector refuse to proceed with the installation at Mr. Benson's home?
Did we refuse?
Yeah, at any point, did you refuse to complete the job?
No.
Okay. And I just want to, the last question I want to ask you is regarding completion times during COVID. Has it taken longer to get materials in the COVID pandemic?
Yes.
Okay. But in this case, the contract was executed at the end of August?
No. Oh, the contract?
Yes.
The contract was wrote on August 28th of 2019.
And your first attempt at installations was in October of the same year?
October 18th of 2019.
All right. And In your experience, is that an unreasonable amount of time?
That is very fast.
Okay. I have no further questions, Your Honor.
All right, thank you. Thank you, Counsel. Any questions that you wish to ask of the witness at this time, Mr. Benson?
Yes.
If you wish to ask her questions, remember, you will have the opportunity to tell me what you wish to tell me, but if you have questions that you want to ask Ms. Parks, you may do so at this time, sir.
Okay. Yes, I didn't get a chance to see the pictures of the doors. My phone faded out or somehow I got disconnected. But Ms. Parks, I think the question I have for you is how many times did we actually speak as far as this work being done?
I cannot give you a number on how many times you and I spoke, sir.
Okay, I believe it was twice. The first time I spoke with you, I think that's when you told me that.
Objection, argumentative, Your Honor.
Yeah, I believe that what your inquiry is, sir, is that, ma'am, do you believe that you spoke with Mr. Benson more than once?
Absolutely, yes.
All right, Mr. Benson, you may continue.
Yes, we spoke twice. The first time was when you said you was having the doors sent out, and I said, okay. So upon the doors coming out, the arrival date that the doors came in, I spoke with you because the door was incorrect. So I spoke with you on the phone, and do you recall you told me that you guys was not going to make any more doors, and I had to accept those doors, and I had to eat the cost of those doors. Do you recall that?
No.
Okay. Well, that's what we spoke on in the conversation. Also, in the original contract, at the very top, do you see where it say tentative initial installation date, and it says 4 weeks of, I think it said 4 weeks of service, I think.
It says 4 weeks
So
or
the job was
sooner.
supposed to be-
It says 4
Okay.
weeks or sooner, and it does say tentative installation date 4 weeks or sooner. Office to reconfirm, due to the nature of this product, we cannot guarantee an installation date. That's on the top of
Okay.
the contract.
Okay. So now, on that day, that second day that we spoke, do you recall, let me see, here. Do you recall on that day when we spoke, I told you, I said, well, I can't use these doors, I'll send them back. And when the job was supposed to have been complete, do you recall, you asked me, what did I think I owed you guys? And I said, nothing. And you said, well, let's settle here, give me $500. Then you said, okay, well, give me.
I'm gonna
Let me stop you. I have to stop you here because I can't allow the parties to get into what their settlement or resolution discussions may have been. It's not proper for the court to hear that, so I can't let you get into that part. Because that's not proper for me to hear attempts at resolution at resolving the case. So whatever those discussions were, they are barred from the court hearing about those things. But you can ask, did we at some point have a discussion about resolving this case? You can ask that question.
Yes, do you recall that, Ms. Parks, that we spoke upon resolving the case? Do you recall that?
I apologize. Can you repeat that question?
Okay, I said, do you recall the day that we spoke, we talked upon resolving this matter?
Yes, we did.
Okay, now, do you recall that I asked you to send me out an itemized bill?
Yes, you did.
Okay, did you send me out an itemized bill?
Yes, I did.
Okay, what was itemized in the bill?
Per your request, it was how much the detailed entry doors were and the labor to cut the hole in the back door and how much that cost.
No, I asked for the itemized bill on the work that you guys did already. That's what I asked you, because you said you guys.
And I'm gonna object again, Your Honor, is argumentative. He's offering facts.
All right, it sounds like you asked the witness what detailed listing of expenses, excuse me. You asked what detailed listing has she sent out?
Yes. So do you have that copy in front of you where you sent me what was supposed to be an itemized bill?
I have a copy of just the entry doors, the work that was done for the entry doors.
Okay, and do you see a balance on that? So the
I
balance
do.
of okay, what balance do you have on that as far as completion?
On that, it says $895.
Okay, and so what now, wasn't that supposed to be the total balance for at the completion of the two doors, the interior doors that you guys did, and
That was
also cutting the hole in the wall?
that was for the completion of just the entry doors. But on that contract, on the very bottom, on where it says other comments, the front security door costs $810 and the back security costs $741. You were only asking for a detailed itemized list of the entry doors only.
No,
But on
I
the
asked you
very,
for itemized. I asked you for an itemized bill for the job that you guys had did already, a complete itemized bill, but you did not send me that. You sent me somewhat of a itemized bill, but it wasn't itemized down to.
I'm gonna object again, Your Honor. He's testifying.
That's not a question. That's something that you're gonna want to tell me when you present your case, sir. Any other questions?
No, I think that's all at this time.
All right. I have a couple questions regarding the contract that has been stipulated to here. Nobody is disputing that a contract was entered into, I believe, on the 28th of August of 2019. There's nothing on that document that states that any of these products are custom. Is that there's no statement that these are custom products, correct, ma'am?
it is not hand wrote that it's custom. No, it does not say custom made.
All right, and of course that doesn't mean that they're not custom, but it just is not anything specified that these are the doors are being custom made, correct?
I apologize. I had some background noise, but on the contract, it is not hand wrote that the products are not custom made.
All right. Or that they are custom made. It's not specified. There's nothing that says that they are custom made products, correct?
Well, on the contract, it does indicate in the paragraphs that all custom made products are non-cancelable.
You're answering, and you know I'm not going to be mean or thing, but you're answering a question that I didn't ask you, right? You do know.
So
that,
yeah,
right?
then I apologize. I would have to say no.
Yeah. I just wanted to make that part clear. The other thing that I wanted to ask you, ma'am, it points out, it seems that the document that was presented to me points out that these were to be spiderweb, and I see some indication of what spiderweb is. There is nothing on this document. Well, let me ask you just a little bit different for my clarification. Does spiderweb mean that there is only one style of spiderweb? Is there only one style of spiderweb, or are there more than one style of spiderweb that is available?
We only offer one style of a spider web.
But in the marketplace, there is something other than that one style. Is that correct?
I cannot say on other companies on what they offer.
Well, I'm not talking about other companies. I'm talking about in the marketplace. I know that you know something about doors. So the spider web is referred to as something more than just one style or one. In other words, you could get spider web in black or white. You could get.
Oh yes.
And there are products called spider web that look different from another product called spider web. Correct?
No.
All right. So every door that is called a spider web door will look exactly the same.
spider web. It could say, for instance, it might say like spider lace. Unfortunately, different manufacturers will call different products that look similar different names. So I don't know if I'm making sense or not.
I got you, man, thank you. There's nothing on this, there's nothing on the contract that makes reference to a particular specification beyond spiderweb, correct?
Correct.
All right. Councilor, based upon the court's question.
Not based on the court's questions, Your Honor. Well, no, one question, I'm sorry. So I just want to clarify, Ms. Parks, that as far as you're aware, in the marketplace, although they may go by different specific names, the spiderweb style of door is a single style of door, correct?
Yes.
Okay.
Are you testifying as to industry standard? Let me ask you, are you an expert in the industry standard regarding whether or not spiderweb always means single spiderweb or double or triple spiderweb? You're not.
No, I'm not an expert, and I don't want to state that is that specific. I don't, the market can be anywhere, so I don't want to answer yes to something that I'm not 100% sure of.
And I appreciate that. I appreciate your honesty and forthright on that issue. And just, okay, I don't have any other questions, ma'am. I appreciate it. Thank you. Counsel, any other questions, sir?
No, Your Honor.
Just one. Was there any other question that you had, Mr. Benson, sir?
No, sir.
All right, thank you. All right, back to you, Counsel. Thank you, Ms. Little. Did I get that right, Ms. Park? I'm not gonna make Ms. Little. Thank you, Ms. Parks.
Thank you.
You know, last two witnesses that I've had over the last 3 or 4 years with the last name Parks was P-A-R-K-E-S, I believe it was. That's why I asked you to spell. I know some people say, you know, it's Parks, P-A-R-K-S.
Right.
But I've had some P-A-R-E-S's and what have you. All right, thank you, ma'am. All right, back to you, Mr. Norman.
Your Honor, I don't have any more questions for this witness, and that would conclude our the plaintiff's presentation.
All right, thank you, counsel. All right, the plaintiff having rested at this time, Mr. Benson, this is your opportunity to present testimony as to what you wish for the court to consider regarding this matter. So I'm going to have you to raise your right hand and be sworn. Well, you've been previously sworn in this case. You understand that you remain under oath at this time, sir?
Yes, sir.
You understand? All right, sir. And you may proceed with offering your testimony as I previously swore you in this case, sir.
Okay, thank you, Your Honor. I'm going to try to make this as brief and short as possible.
I'll help you with that. Because
it's basically, yes, okay, thank you. Because it's really long drawn out because, you know, when Kenny was the salesperson that came out to my home. He came out to my home. I had a picture of the old spiderweb door that they made in the 80s, 90s, whatever that was. It was a 3-tier, like I said. I asked him, could he make that door? He said he guaranteed me that they could make that door. And as a matter of fact, he got on the phone, he called the company, and he basically talked to them and told them what picture he had. They guaranteed him that they could still make that door, even though they had discontinued it, but they could still make that door. So I said, okay, no problem. So at that time, we went ahead and after he got off the phone, we signed. I signed the paperwork and I gave him a $1,400 down to him. And he assured me that everything would be delivered and done within the 4 weeks, which should have been like September. but the job wasn't, the job still not complete, but the two interior doors and the hole that was cut out the wall, that was done roughly about the middle part of January of this year, which should have been so much sooner. And also, I very little spoke with Mrs. Parks. I basically spoke with the sales lady, Teresa. I guess she's not around. Teresa and Kenny is not here today. But those are the two people that I mainly spoke with. I only spoke with Ms. Parks on two occasions. So my thing is, I don't feel that I owe him anything. If I owe anything, maybe $200 just in good faith, because when I spoke to Miss Parks, you know, upon them coming to pick the doors up that they had left, which was still the wrong doors, she said, let's settle this. So I said, okay, well,
Let me
I don't
stop
really
you.
owe you guys anything.
You can't talk about any amounts that you might have been talking about for purposes of settlement. You can't talk about that. And there, you certainly solicited testimony that there were some attempts to get this settled. I can't let you get into the details of that at all, okay? But I know that you attempted to settle it. I know that Ms. Parks attempted to settle it with you, and you guys were not able to work that out. And whatever numbers it was, I don't want to know about that because I can't know about that, okay? You can continue with your.
Okay. Well, continuing as I was saying, the job was never complete. So I feel that they breached the contract. And basically, when I spoke with Kenny, I basically thought there was I actually thought there was Empire Door, because they have both of the buildings that Empire Door had. So that was one of the reasons that went ahead and made me sign, and he assured me that he can make the doors, which obviously they didn't complete the job. But I don't feel that I owe anything, you know, because the job was incomplete, and each time they came out with the doors, they was wrong doors. The first time the doors was wrong, but since they had took my security door down from the front security door, so they put the wrong security door up, which was the peacock, and the back door, they cut the hole in, they put the door in, and I ended up with mice for the simple fact I never had mice in my home, but I ended up with mice from when they cut the back door out. They didn't finish it out. They left it open. They left gaps in between until they came back out to finish it. Mind you, during that time, excuse me, it snowed a lot that year. And so they left the door, the rear door open, basically with gaps in it, and air was coming through there. And they didn't install a security door for the simple fact it would have torn up the brick molding that they had to put up. So they didn't install the back door. But they did install the front door, which was the wrong door. Both doors was on the interior and exterior. The back door that they put up, it was the right wagon wheel door. It was the interior was the right door, so they installed that. So then they had to come back out and keep coming back out. Each time they came out with the wrong doors. So when they did come out with the doors that were supposed to be the right doors, before he took them out the truck, I said, well, I want to take a look at them. So I looked at the doors. It was the wrong doors. I said, that's not what Kenny assured me that you guys could do. So the doors back. And that's when I spoke with Trinity on the phone. And she said that they wasn't going to make me any more doors. I had to eat the cost of the doors, and I was just stuck with the doors. So I said, well, if I'm going to get stuck with the doors, can I have all 4 of the doors that you guys made? He said, no, they goes to the showroom. So one door, which was the front door, which is an odd number door, it was a 34 by 82. So they had to basically fabricate that door, the security door, as well as the interior door. So I just think we should just call this even, because they did a terrible job, poor job. Now, Brian, the worker, he's a great guy. I love him. He's a good guy. He did a great job, and he was very polite and very professional. But the person that I dealt with, Teresa and Trinity, they wasn't very professional at all. And I was asked, and I didn't bug them or call them to ask them, like, when is the doors going to be completed? I was just trying to give them time so the job could have been done right. But it's still job is not complete. So I had to go and get my security doors made elsewhere, which I went to Empire Door and got my security doors made. And they installed the security doors on what day was that? I think it was I'm trying to find the date. On 1/3/20. So that's when Empire came out and installed my security doors.
And how much money did you spend getting the security doors installed, sir?
I paid $1,403, $1,403 at Empire Doors. And it's a sturdier door, better made door than what they have. Their doors are universal to where you could flip the door. If they come out with the wrong door, they can flip the doors over and change the hinges on the doors so it makes it fit.
All right, so
but the doors from Empire, they're fusion welded doors. So if they come out with the wrong door, then they have to go back to the factory and remake the door.
and the $1,403 is for 2 security doors, is that correct?
Yes, front and back. Spider web.
All right, now, you indicated, and someone else may have some questions for you, but you indicated earlier in your test.
Say that again, Your Honor.
1 second, excuse me.
Yeah. So they will. So they need to be out there. I don't want to take it. So stand by.
Just stand by. You would think that parking in the spaces allow for judges to park with the safe, but still someone hit by the car. That's why I was rushing. So a U-Haul truck is stuck up against my vehicle that's parked outside. That's what's going on. But I'm back on this. We'll deal with those things in a moment. Just tell them to stand by. All right. You testified, sir, that at the time that Mr. Little came out with the security doors, that you showed him a photograph, and Mr. Little told you that they didn't make that kind of door. That was old-fashioned door, correct?
Yes.
Well, that's what. All right. That photograph. So then you in your testimony just now, you said something that you talked to a Kenny.
Yes, I did. Kenny was the salesperson on August 28, 2019.
Did you show him that photograph that at the time that you were entering the contract?
Yes, I did.
And is that why he put down spider doors?
I'm not sure why he put it down, but I think that is. But I know he called the company while he was sitting at my dining room table before I signed the contract. He called the company. I think he wrote the number at the bottom of the 313 number 687-6228. I think that's the company that does their fusion welding or whatever, fabricate their doors. So he called them and they guaranteed him that they could still make that door. But when the doors came out, it was all wrong from the beginning.
All right, sir. Okay, go ahead. Anything else you want to say? And now give opportunity for Mr. Norman to ask questions of you if he wishes to do so. Anything else you want to tell?
Your Honor, I think that's all I need to say as first today. I just don't feel like this. I should have to pay for a half job that's incomplete. And the doors that they made, that was on their behalf that they made the wrong doors, because we had the full discussion. I even called Teresa over the phone and I spoke with her and she assured me as well that they can make those doors. And because when I called Teresa, I asked them, at first the one with the mail slot, could they actually make it like a little thicker, like put another sheet of metal behind that mail slot so it could make the door extra durable? And she said yes, but it will cost me, I don't remember what it cost me, but it cost me an extra $100 or $200 or something like that. But either which way, like I said, they still had the wrong doors. Each time they came out, and they probably came out at least 5 or 6 different times with the wrong doors. So I just think that they just so very unprofessional.
All right, sir. All right, thank you, sir. All right, Mr. Norman.
Just briefly, Mr. Benson, the spiderweb doors that you got from Empire are the same style as the ones that were offered from Protector, correct, as far as visually?
Visually, yes.
Okay, so it was the same type of spider web.
No, it's not the same type of spider web, but it's a different type of spider web.
Let me just clarify. So when I asked you the door, the spider web design that you recently installed is visually the same as what Protector was attempting to install.
No, it's a different spider web. It's ended up being a 2-tier spider web because they said it discontinued. So he told me they couldn't make that door. So it's a 2-tier spider web, but it's very different from the spider web that Protector made.
Okay, so I just want to clarify. You said you refused the Protector doors because they were not the 3-tier spider web. And
yes, if he hadn't told me that he could make that door, then I probably would have went with the 2-tier from the beginning because I wanted the spider web door. But Kenny assured me that they can still do the 3-tier.
Okay, but what you have installed now is a 2-tier spider web, which is what Protector was offering.
I have a 2-tier, but it's different from Protector door.
Okay, I don't have any other questions, Your Honor.
All right, Mr. Benson, anything further you wish to present to me at this time, sir?
Well, my thing is basically they say they can't use the doors. So I'm asking, could I get those doors? Will the court allow me to get those doors? But they said they can't use.
All right, thank you, sir. All right.
Thank you.
All right, that is the close of the defendant's proofs in this matter, and it's back to plaintiff for summation, if you will, sir.
Yep, just brief closing, Your Honor. It's no one disputes there was a contract here. Mr. Benson's testimony was he understood he was getting custom products. He never canceled them. My client made all attempts to install the products he requested. Only reason they were not installed is because he refused them. My client still has them and is prepared to provide them. And it's also, I'd just like to point out to the court the last testimony, which is he ended up with the 2-tier spiderweb doors, which my client was prepared to install. And he's just trying not to fulfill the contract. So we're requesting that the court award judgment in the amount of $2,446 for the unpaid portion of the contract. My client would obviously be happy to provide the doors, which they've attempted to on multiple occasions, even by Mr. Benson's testimony. In addition, we're asking for $206 in court cost and $1,500 in attorney's fees.
All right, thank you, counsel. Mr. Benson, in summation, this is your last opportunity to summarize anything that you want to summarize and what you're asking the court to do, and then we'll be back to Mr. Norman. That will be the close of this matter.
Well, my thing for asking for, I really don't want the doors or need the doors because my Empire came out and completed the job that they should have completed. And I shouldn't have to take any kind of material that I didn't order or have to accept that the doors because they was made wrong. I don't think that would be fair to me to accept something that I can't use. Nonetheless, I'm gonna have to pay. If I'm gonna have to pay, then yes, I would like to have the doors. But paying $2,000 some for incomplete job, I think that's just totally just not right at all. So I don't feel that I owe them anything because I feel that we're even. They got the doors that they can resell the doors within their warehouse. So I don't feel like I should have to pay anything else as far as this job because it was very incomplete and unprofessional. Thank you, Your Honor.
Thank you, sir. And Mr. Norman, you get the last word, if any, sir.
Yes, Your Honor. This is a contract case. There was an agreed upon contract. My client attempted to, there's no dispute that my client attempted to comply with the contract and was only turned away by Mr. Benson. And so he's got 2 doors installed, security doors installed. And so we believe he owes the balance of the contract as agreed upon for a total of $4,152, Your Honor.
All right, thank you, counsel. And thank you, Mr. Benson. Thank you to all of the witnesses, as usual, and not in every case, but in many cases, it turns out to be more interesting to the court than I even anticipated. Mr. Norman, in his closing argument, reiterated the significance of being before the court as it relates to issues that bring parties together. The critical issue that brings parties together is that which is described as a contract. The contract is a significant document that expresses to the court the agreement that exists between the parties, because of course the court was not there to be a part of that, was not there to engage in and hear the conversations that may have been involved. So the contract becomes an important and significant part of this case. So this is a contractual case. And there is undisputed that Mr. Benson contracted with Protective Windows and Doors for the installation of 4 doors, 2 that are described as security doors and 2 that are described as interior doors. And with that was the cutting out and the framing or reframing of an entryway. Those services of reframing an entryway and offering the doors to the premises were services that were contracted for and services that were provided. The issue that really is raised in this case has to do with the security doors that are spiderweb security doors, and that has to do with some issues that Mr. Benson has raised regarding workmanship on the installation or the cutting of the new entryway. The critical issue here has to do with what occurred at the time of contracting. And one of the most significant things that happens in this case, as I've listened to it, and I do believe that as I've listened to the witnesses, that all of the witnesses making a very honest effort to communicate to the court to the best of their ability what the truth was regarding what was involved here. And when that occurs, oftentimes there are things that the court will see that the court has to fathom what does that mean. Well, when Mr. Little was testifying, Mr. Little indicated that when he brought the door out, the security doors out, that he was shown a door by Mr. Benson, and Mr. Benson was making hay about, this is not the door that I contracted for. This is not the security door that I contracted for. And it's at that time that Mr. Little says to him, "Well, that's an old style. They don't make them like that anymore." It's obvious to me, and the testimony makes sense to me because Mr. Benson testifies that despite the fact that Mr. Little tells him at some point that he can't install the door that he wants, and this is it, this is what we're going to install. He indicates that Mr. Little was very professional, very businesslike, very to accomplishing the job that he was set out to do. That the disagreement really was over those security doors, and the problem with that with that part of this case is that just as Mr. Benson showed that photo on his phone to Mr. Little, Mr. Benson indicates that that's what he showed to the person that he contracted with, and he indicated that person's name on this record, who is not here to testify, one by the name of Kenny, indicated that when Kenny came out and he signed off the contract, that he showed Mr. Kenny the same thing that he later showed Mr. Little. And when he showed that to Kenny indicates that Kenny told him and made some calls and verified that he would be able to provide that which was being shown to him on the phone photo that was being indicated. And then the contract is drawn up indicating spider web security doors, and it doesn't have any other specifications. And so obviously, Mr. Benson contracted for something, at least as it relates to those security doors, that was different from what was brought out. And that difference was unacceptable to him because of the fact that Kenny told him that what he showed him is what could be provided. Ultimately, thanks to the inquiry of counsel, Mr. Norman, in this matter, it appears that Mr. Little was right, Kenny was wrong. That is that Mr. Little, when he saw the photo at the time of install, he says you can't get them like that anymore. Somebody told Mr. Benson that you could get that type of door, and that the plaintiff in this matter, Protective Windows and Doors, could in fact supply that door. That's a critical part of this case, because the doors that were brought to Mr. Benson were not the doors that he contracted for, but moreover, they were not a door that was available, although he was led to believe that such a door might be available. Essentially, what you have in this case, then, in the first instance, is that the testimony of Ms. Parks indicates to the court that the cost of those doors are somewhere in the ballpark of some $1,900 as the cost of those doors. So the balance that remains on the contract is $24.46, so $546 in the first instance for ready and available service to install, to correct doors, to cut holes, et cetera. That difference in the first instance would certainly be owed to Protective Windows and Doors. And the court is pondering, what of that $1,900 is a mistake of contract that would inure any of the responsibility to the defendant in this matter? Because obviously the parties entered into a contract, and a part of their entry into that contract was a mistake of fact. In fact, the door that Mr. Benson showed to Kenny was not a door that was available. But I'm persuaded that Kenny told him that Protector could provide that door, and that's the door that he anticipated that they would provide. That was a mistake. That was clearly a mistake of fact. And the question then becomes, who has to bear the risk of loss, the cost of loss, when there's a mistake of fact? Well, Mr. Benson is not an expert in doors. Mr. Benson does not have any dealings in doors. Mr. Benson does not have any experience in doors. Mr. Benson doesn't know anything about whether a door is outdated, not available, can't get that one. He doesn't know anything about that. He doesn't discover that, in fact, until he goes to another outlet to get a door that he believes to be better doors, but they are of the nature of the doors that are like unto the ones that were offered by Protective Windows and Doors. So that's the ball of wax in this whole situation. Protective Windows has to bear the cost of the creation of those doors because of that communication by Kenny. The issue, the final issue then becomes, well, not the final issue, but just before the final issue becomes the issue of whether or not Mr. Benson was duty bound to accept this version of the doors or another version of two-pronged spider doors at the time that he found out that the third pronged spider doors that he had a mistake in fact about, that he was communicated a mistake of fact about whether he had a duty to accept those doors at that time. And I can't phantom that he would have a duty to accept those doors. But the mistake of fact is some of that mistake of fact is something that he would have some responsibility in, and I'll calculate that responsibility at 10%. It's basically $200. The court would fine for the plaintiff in the amount of $746. The plaintiff would be entitled to recover the cost of the litigation, which is in the nature of $206. And the court will grant an attorney fee in this matter, as would normally be capped. It would be granted at $250. The court then will grant judgment for the plaintiff in this in the amount of $1,202. Judgment will be for the plaintiff in the amount of $1,202. If the defendant decides that he wants the doors that are still had, that would mean that the defendant then would have an obligation to pay $1,700 for those doors, unless there is a compromise reached between the parties otherwise. So if Mr. Benson wants the doors that were made, if he wants those doors, he would be obligated to pay $1,700 unless the parties bargain for something different than that. Otherwise, he would not be entitled to the doors under this judgment. Judgment is for the plaintiff in the total amount of $1,202, $746 as damages, $206. This court costs $250 as a statutory attorney fee. It is so ordered at this time.
Your Honor, thank you for that judgment. My last question is regarding the security doors that were installed by Protector on Mr. Benson's home. Can my client recover those doors that were originally installed?
No, not at all. I didn't get that part. Are there some doors that Benson has that were installed that were removed and replaced? Mr. Benson, is that what happened?
Yes, Protector, they have all four of the doors, because the last two doors that came out, which was supposed to be the spider web, before they took them off the truck, I looked at the doors. They was wrong. The peacock doors, they picked those doors up on the last day they came out to pick up the doors. I had already had Empire install my security doors already. So Protector has all four of the doors that they basically made up for my home. But they, like I said, they was all the wrong doors.
That's what sounded like the testimony to me previously in the case. So, well, my judgment says if there's going to be an exchange of doors, it would be if Mr. Benson wanted to purchase two doors that would be in the amount of $1,700 that he would have to pay in order to retrieve those doors if he wanted to. And I make no other findings in this regard. Judgment as I indicated.
Thank you, Your Honor.
Your Honor, it was.
I'm listening, Mr. Benson. Go ahead, sir.
Yes, it was four, a total of four doors together. The peacock doors and the spider web doors. Those are the four doors, security doors that they made. So it's not two, it's four doors altogether, security doors.
Well, my understanding is that they installed two doors for you, and then there were to be two additional doors installed, correct?
Yes, but each, like I said, it came out 5 to 6 times, but each time they came out, they had the wrong doors. The first time, that's when they brought out the peacock doors. They were wrong. So the peacock doors stayed on the front door, and the other sit in my kitchen until they came out to complete the job. But they came out with the spider web doors. That's when they came out with the spider web doors, that's the day they picked up the peacock door. Because I had already had Empire to come out and install the spider web doors. So it was four doors total.
Gotcha. I'm going to leave this case where it is. If you wanted to pick up two doors, you at $1,700, you could pick up two doors, two security doors. You could pick up two security. If you wanted to do that, that's what I'm saying. That's beyond this case. That's, I'm not putting that in order as such, but that's how this case would be resolved. If you wanted those doors, that's what you'd have to pay for unless you bargain for something less than that. Otherwise, the case is resolved based upon my judgment determination in the amount of $1,202. That's what you have to pay to protect the doors, sir. You'll get a
Okay, yeah.
judgment.
Well, yes,
All right.
sir. I don't want those doors, not at that price.
That's up to you. All right. I wish you well. Good day to all. Counsel, you going to submit a judgment or you want the court to just issue one and send it out? What do you want me to do? And yeah, you're on mute now. You're doing a Mr. Benson on me now.
I'm doing a Mr. Benson. I said, you know, the court would provide it. That would be great. But if you'd like me to do it, I can do it, Your Honor. And submit it.
I'll get an order out and we'll get it sent out in the mail. All right. All right. Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Have a good day now. Good day to all.
Bye,
All right.
thank you.